This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Welcome back. Nice to have you with us this Sunday morning. Our guests in studio from Lindsay Kenney LLP are Angela Thiel and Christine Eilers, attorneys both, and we're talking about methods for resolving family law disputes. And I just called my guests attorneys. That's an American phrase. And I got, the look. Oh, if looks could kill, I'd be lying on the floor. Well, let's talk a little bit about prenuptial agreements. Christine, let's start with you this time around. We're talking about methods for resolving family law disputes. We've talked about mediation and arbitration. In many cases, it's the terribly unromantic prenuptial agreement that some couples feel compelled to enter into before getting married. If the marriage goes south, does the prenup, Christine, become the template for the separation agreement? Isn't that why they did it in the first place?
Ideally, that's the case, that the parties will look at the prenup or the marriage agreement at the end of the day and say that sort of things went as contemplated and the marriage agreement can apply. And then it's just a matter of applying it. So you look at if there was, for instance, one party got to keep their initial investment in the property,
right.
Then you sort of back that out of what they have at the end of the day and figure out what's left and divide it according to the agreement. Usually you have to figure out what spousal support is going to be, what the child support is going to be. So there's a few little things you need to figure out, but ideally the marriage agreement from the beginning will be reflected in the separation agreement at the end.
Okay, now this is something, Angela, you and I have had this conversation a few times now, and you know, I feel it is the least romantic thing anyone can do prior to popping the question. But nonetheless, a lot of people see fit and are advised by their lawyers to consider this option before entering into the marriage. What isn't included in a prenup that eventually gets discussed at the end? Obviously, you can't talk about children in a prenup because there aren't any in most cases, unless there are children from a previous marriage being involved. In that case, would there be some inclusion of those children in a prenup, possibly, Angela?
Well, as we probably have told you along the way, you can't contract out of child support. Where you might talk about children in a prenup is this sort of idea of, well, now this is going to be my stepchild.
Right.
There is a specific provision in the new act and was already in the law about, well, if the natural father is already providing for that child and his income level is, say, $50,000, you're always going to, you, Mom, are always going to make sure that you get that from him.
Mm-hmm.
And so all I'm going to be liable for perhaps is that extra bit if I make 100.
Right.
So that might go in a family law agreement now. Because you can't contract out of child support, you're really just sort of documenting that fact,
right,
that there is somebody paying a certain amount for that fellow. But it also sort of, because it may be something people don't know, they may not know that if they marry a woman with a child, they take on this child support obligation. So that's part of a discussion about, oh, you mean because the father of this child pays nothing, or we don't know where he is,
right.
I'm taking on the entire responsibility for this child financially.
And let me stop you there, because there's another element to that fact that perhaps we should discuss, or at least open up, because you don't have to be married to the woman in question with the child to be liable for child support, do you, Christine? If you're in a relationship with that woman for, a year or 2 years, then marriage or not,
Yep,
you are responsible for the well-being of that child.
It depends on a few factors, like if you've been contributing to the child's upbringing and well-being financially throughout that period.
Right.
But yes, you can definitely incur liability without realizing it.
Well, and that's something that, again, people just need to know, Angela.
Yeah.
They just need to know. People don't know a lot of basic things. And the new Family Law Act that we've talked about already on the program, does that include these provisions, for example, with child support for non-married people who've been in a relationship for a year? Is that part of the new Family Act, Christine?
It is. Yeah.
Okay.
Mm-hmm.
It already was the law. It was in the old act, but it spells it out a little bit more clearly, and it also spells out the primary obligation is still the biological father,
Okay.
or mother, as the case may be.
Mm-hmm.
But if you are common law, which is 2 years, and have contributed to the child's well-being for a year, and that's direct or indirect. You don't have to hand him money.
Right, right.
But if you own the house in which he and his mother are living, then you've indirectly contributed to his support.
Interesting.
And, if you think about it, a 2-year relationship with a woman with a 3-year-old can give you an obligation. Now the child is 5. That's
Right.
an obligation for another, 15, 20 years.
Right. Interesting details, and as the law changes, we need to change our thinking to get up to speed with it, right? Let's talk now. We're talking about methods of resolving family law disputes, and one thing that you suggested, Christine, would be the common sense approach, where the parties actually are able, in civil means, to sit down and discuss the terms of the dissolution of the marriage. Not always possible. Sometimes, for example, those sorts of one-on-one negotiations need a little guidance. Maybe not arbitration or mediation, but maybe a lawyer. Now, if lawyers get involved, would it be advisable for both parties to have lawyers advising them as they attempt to do it themselves?
It's definitely preferable for both parties to have lawyers at that point. And I mean, really, that's better because when they're sitting around the kitchen table talking about what they want out of the relationship, they don't know what their legal rights and their legal obligations are. And they can come up with something that's just totally out of left field.
Right.
And so once lawyers are actually involved and the parties have a good understanding of what their rights and obligations are, you come to the table with a different perspective, and the lawyers can assist the parties to negotiate a agreement. And often that's just done by, letters back and forth, telephone calls, sometimes 4-way meetings, and hopefully no court, but sometimes court as well.
So now let's assume that whatever method of resolving family disputes, it's successful. There is a resolution achieved between the two parties, maybe with lawyers, maybe not. How does that get formalized and finalized? Does a judge have to sign off on the end agreement?
No, a judge doesn't have to sign off on the end agreement. There's a number of different ways you can document an agreement. A settlement agreement is a common one, and that's usually drafted by a lawyer, signed by both parties and their lawyers. But you can also do a consent order if you come to a resolution, and that's a court order signed off by a judge, usually a little bit more of a simple document. Or, of course, if you end up having to fight it out in court, then that's an order at the end of the day.
Okay. Now, short of going to court, and we'll talk about that because that's a whole other game, really. Angela, in your experience, and we're talking about some relatively new twists to the plot in terms of means of resolving family disputes, what in your experience is the most proven and most successful method and most commonly used these days?
I think that they are sort of even with respect to, I think mediation is really successful with mature, civilized, amicable people that have the same degree of knowledge of their financial affairs
Right.
and same degree of concern about not letting this screw up our kids. Mediation with good mediators, with or without counsel present. And I balance that with negotiation between 2 good lawyers and 2 good clients. The reason mediation works quite effectively sometimes is because you're all in the same room and you're going to stay in that same room hopefully until you get it done.
Right.
One of the problems with negotiations with lawyers, and we see it quite often, is that those of us that spend time in court are also sort of coming back after court and trying to send letters and make phone calls and write emails. And if we there's a bit of a time delay. Just I personally hate writing letters back forth.
Right.
I just as soon get on the phone with another lawyer,
Sure.
or at least pop them a quick email. So if you can have a 4-way meeting with just you, your clients, and the other lawyers, I find that's as effective as mediation.
Okay. And that's traditional negotiation, right? So what's the difference between traditional negotiation, Christine, and collaborative law, or is it the same thing?
No, it's not the same thing. Collaborative law is a different form of resolving a family law dispute where both parties do have their own lawyers, but you sign in what's called a participation agreement at the beginning of the process that says that you agree you won't go to court, and if you do go to court, you both have to get new lawyers, and everything sort of that was talked about within the process is confidential and you can't use it later.
Oh.
The collaborative law process tends to involve a lot of other professionals. Parties have divorce coaches, financial specialists, child counselors, things like that are all involved. So it's a very sort of holistic approach that works really well for some people who need that additional support.
What is a divorce coach, Angela? What? I've never heard of one before.
Well, I'm going to be cynical here and say you'd have to ask Christine what a divorce coach is. Actually, for some people, this works really well. A divorce coach is most often a psychologist that helps people deal with their emotions and the emotions of the kids and keeping it all civilized and, working out parenting schedules often.
Okay.
But in terms of it being this holistic approach, it's a lot of assistance from professionals. It's and they're very good professionals. I'm sure you've heard me say on this show more than once that I don't like the concept of collaborative law that you have to agree to be stuck in it, because if it doesn't work, it can be very expensive,
Right.
and then you have to start all over again. But it's a trend, and fortunately, Christine is going to, as a young lawyer, is going to keep going on that trend, and I'm just going to be cynical.
Oh, okay.
The idea is to sort of remove the positional approach in negotiations, and really there's not that threat of litigation lurking in the background. So you really feel that you're coming to the table and you have to resolve the dispute. So it's just a different approach in that sense, which, I understand the benefits of both.
Right.
both
Now,
ways of
one of the
negotiating.
things that, and you've explained this to us before, Angela, whenever a client comes to you or any other family law practitioner in British Columbia, you have to advise that person that they should try and reconcile their differences with the party that they're here to see you about and get rid of. You have to, in some way, you have to say, no, wait a second. Are you sure it's over? Have you exercised all available options for carrying the thing forward? You have to do that, don't
Absolutely. You have to do it. You have an ethical obligation. You have to sign a document when you issue a divorce proceeding saying you've done it. You also now have to execute a document saying, and I've suggested some other resolution techniques to you other than going to court.
Okay, and those are the ones we've been talking about today. Okay.
But I don't want to be moralistic, but I think that I sort of have a responsibility to say, look, counseling does work. So one of the first things I do ask when we're having this discussion is, have you had any counseling? And if someone says, we've been in counseling for 2 years,
Right.
or we've tried it 3-4 times.
And I'm sure a lot of people have. This comes out a result of considerable effort to not break the marriage up.
Absolutely.
Right?
Absolutely. So if I hear that, then, I feel much better. But every so often people come in and it's just been the terrible fight.
Right.
And they haven't really thought through what will my life be and what will my children's life be. I say it this way is, well, people think, well, I never have to see that jerk again.
Mm-hmm.
That jerk will remain the father of your children.
That's
You're
right.
going to see him every few days, every second weekend.
Mm-hmm.
You're going to have to worry about his finances because he's supposed to be paying you. He's going to have to worry about, your finances. And so you never, you can't say, well, I can go to this lawyer and get rid of this jerk.
Mm.
Sometimes you can, short marriage, the starter marriage.
Uh-huh.
You may never have to see the guy
No
again.
kids, yeah.
Well, let's take a break here, and when we come back, we'll talk about what I'm sure on many occasions is the most difficult part of your job, and that's diffusing the emotions, bringing the emotional quotient down to manageable levels. This is terribly emotional stuff. And we're talking with two very skilled lawyers from Lindsay Kenney LLP. Angela Thiel and Christine Eilers are with us. You can check out the website during this break. It's lklaw.ca. As long as you're back with us in about 3 minutes or so, because we'll be here.
This is AM 650's The Law Show. There's more of the show still ahead.